Look out, folks, you're about to get conned. And no, I don't mean we're going to trick you. We've got constitutional law professor and author Timothy Sandefur with us today. And we're really excited to hear from him about some interesting developments in privacy, intellectual property, commercial speech, and economic freedom. Evan Brown's going to keep us on track, too, next on This Week in Law.
Netcasts you love.
From people you trust.
This is TWiL.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, episode 121, recorded July 22nd, 2011. Funeral urns and worm poop. This episode of This Week in Law is brought to you by Netflix. Watch thousands of TV episodes and movies on your PC, Mac, iPad, iPhone, or TV instantly. All streamed directly to you, saving you time, money, and hassle. For your free 30-day trial, go to netflix.com/twit. Hi, folks. Denise Howell here, and you've joined us for This Week in Law. I'm really excited to have an old friend and acquaintance of mine, Professor and author Timothy Sandefur, joining us today on TWiL. Hello, Tim.
Hi, thanks for having me on.
It's great to see you again, and it's great to have you with us fully clothed. The first time I met Tim, we were at...
You can cut it there.
Yeah, just cut right there. We were at Chapman University Law School where he used to teach. He now teaches at McGeorge up in Sacramento. And this was back in 2006, and we were at a little symposium on the blogosphere and the law, and I'm very proud of this. This is the first time I've ever been actually published in a legal journal. It's called the Nexus Journal of Opinion, and so we're both in there. And this was back when the blogosphere, or bloggers, were often called the pajama hadeen, and the knock on them was that them/us, is we would sit around in our pajamas and just spew opinions out into the void. And so I think in protest or embracing of that concept, Tim showed up to this symposium in his jammies, which were quite stylish, as I recall.
Now, a couple of corrections. The first one is I actually never taught at Chapman. I'm a Chapman graduate and was speaking as a practitioner at that time. The second thing is the actual story is that on my flight down to Southern California, I discovered that I had forgotten to bring a tie, and I realized on the flight down first that I would be more embarrassed to present a speech not wearing a tie than to present a speech wearing pajamas. And secondly, that the pajamas would be appropriate given the subject matter of the conference. So I quickly borrowed a set of my father's pajamas and gave the speech that way.
It was wonderful.
It was mostly because I forgot my tie.
I love it. Anybody who shows up to a conference with me in pajamas is going to get invited on this show. That's my standing rule. So I'm sorry it's taken so long to get around to it, and I'm really looking forward to picking your brain and getting your 10,000-foot level thoughts on some very big issues in the world today. Also joining us is Evan Brown.
Hey, how's it going? And I'm so glad to be on the show, even though the one time that you and I have met, I was wearing a tie. So I'm glad to make it onto the show.
That's right. That's right. You didn't show up in pajamas, but we managed to give you a pass on that. At least you're not wearing a tie today. So
no. Very, very rarely on Fridays.
That's helpful. All right. So the first issue I want to get into today, and there are so many good, juicy issues that we can dig into on the constitutional law front, because when you think about it, it's the foundation for much of the law that governs our lives in this country. Some might argue the ultimate foundation of our law in this country. So let's start with privacy, since these are issues that come up all the time, and the right of privacy, one way or another, goes back to the Constitution, depending on which Supreme Court justice you talk to and their analysis of that. And also, of course, the Fourth Amendment to the Constitution is something that is written right there in the Bill of Rights. So we've got some cases coming up to the Supreme Court, one in its next term concerning GPS devices placed on cars. This is an issue in California that we've talked about on the show before, where an officer planted a GPS device on a car parked in somebody's driveway. And in California, the Ninth Circuit, here where I live, the court decided that that was okay. But in other circuits of the United States, different courts have gone different ways on that, and we're going to get one of those cases before the Supreme Court next term. So I wanted to jump into that and just kind of get your thoughts, Tim, on where you think this is going, and any take on how the court might handle this issue.
Well, I'm certainly not an expert on Fourth Amendment law, which is a very complicated area of jurisprudence, and unfortunately it's one that, in my view, has been corrupted, might be not too strong a term, in large part by the unconstitutional, unjustifiable, unwinnable, immoral war on drugs, which has led to the virtual eradication of the Fourth Amendment in many contexts. There's a brand new book out that I would like to recommend to everybody called The Rights of the People by David Shipler, a Pulitzer Prize-winning journalist, that chronicles the virtual eradication of the Fourth Amendment as a result of the war on drugs. The Fourth Amendment says we cannot be subject to searches without some sort of suspicion, but so many exceptions have been devised, some of them really, in my view, absurd, that the warrant requirement applies almost more the exception than the rule now.
Mm-hmm. What I think is interesting about this GPS tracking issue is I think it cuts across party lines. I linked in our discussion points for the show to an op-ed in the Washington Examiner by a gentleman named Frank Miniter, and it's titled "Whatever Happened to Our Right of Privacy?" And he casts this in sort of terms of right versus left, and it's the Obama administration who want to obliterate the Fourth Amendment here and blow forward with making GPS tracking the norm. And I take issue with that. I'm a pretty liberal sort of person, generally a Democratic voter, and I'm very fond of the Fourth Amendment being applied in a reasonable way that defends people's reasonable expectations of privacy. So do you agree? I don't think it's really a partisan issue.
Oh, yeah, no, definitely. Throughout constitutional law, you find that the simple conservative-liberal dichotomy really breaks down in general. You find some of the best civil liberties decisions in the context of criminal law being written by the traditional conservative so-called justices, and you find some of the worst decisions being written by the liberal justices sometimes, and vice versa. So no, it certainly does not follow party lines. And on the other side, the violations of constitutional rights do not follow party lines. I think the drug war is a supreme example of that. Even though President Obama promised during the campaign to cut down or to eliminate the federal raids on legal medical marijuana dispensaries, he never went ahead and enforced that. There was some rhetoric to that effect, and most recently we've learned that the federal government is going to press forward with raids on legal medical marijuana dispensaries, that is, dispensaries that are legal under state law. Here's a violation not only of the constitutional principles of limited powers, but the right of states to set their own policies, and, of course, the president's promise to try and act in a slightly more humane manner when it comes to America's drug laws.
Evan, have you taken a look at Judge Kaczynski's dissent here in the Ninth Circuit case I was talking about? They were looking for an en banc hearing, which would have given them the chance to undo their ruling allowing the search, which was not granted. So Judge Kaczynski was upset with this and wrote a rather scathing and eloquent dissent, as is his wont. And Oren Kerr over on the Volokh conspiracy characterized this as Boone replied to Otter, forget it, he's rolling. And he was really on a roll. Have you read that? And do you have any take on what the Supreme Court might do with the issue in the case that it's going to hear?
Well, as we know, Judge Kaczynski, is usually on a roll. He says some great things, and, unlike so many other judges at the federal appellate level, it's pretty unambiguous what he's trying to say. He says it in his stark of language here. The needs of law enforcement to which my colleagues, meaning the other judges on the panel, seem inclined to refuse nothing are quickly making personal privacy a distant memory. And here's where he really drives it home. 1984 may have come a bit later than predicted, but it's here at last. Mm-hmm. That's putting a pretty fine point on it all here, and he makes some really good points here, and he's very stark in his rationalization of why the decision in this GPS case that we're talking about was wrong, focusing very heavily on the idea of curtilage and the protection that has. That's this kind of this extension. He characterizes it as the part that rounds out the personal privacy that you have at home. So as far as knowing what the Supreme Court is going to do, I don't have the magic crystal ball to do that. Many people much smarter than I am who follow the court much closer would have something meaningful to say on that. But I guess the important point from my perspective here that I see is to underscore what we were saying earlier, how this really does not seem to be a partisan issue. And we've made this observation before. A lot of these constitutional issues can be, the different sides of the issue can be promoted and espoused by both sides of the political spectrum. The First Amendment provides us some great opportunities for this as well. We were talking about the California statute that outlawed or tried to outlaw adult video games, or like violent video games, for keeping them out of the hands and out of the view of children. You could look at that both from the left and both from the right. Same way with a lot of these privacy issues. This editorial in the Washingtonian, seemed to be more coming from the perspective of just trying to skewer the left and saying, well, because the Obama administration is taking this position, therefore that's representative of the left, and kind of disregard the fact that the ACLU and all of the other organizations out there so interested in preserving these civil liberties, keeping intact the interests and the strictures of the Fourth Amendment. Those are usually characterized as more liberal types of organizations. It really does away with that. So going back to what Judge Kozinski says here, if anything, we know that it's a very serious issue because of the fine point that he has put on it, invoking imagery and notions, namely George Orwell's 1984. That's something that we can all understand and identify with, and certainly be fearful of as well.
I love that he threw in his chicken coop too. Actually, was speaking of chicken coops in general, but as he is,
it comes down more to a pro-government tendency or a pro-individual tendency when it comes to the law. We're saying that it's not a partisan issue being supportive or opposed to these constitutional rights. Really, there are different dichotomies that make more sense in constitutional law, and the pro-government versus pro-individual dichotomy is more sensible. And what we find is that just because of the political system, justices tend to get past the appointment process if they are pro-government, because, of course, the elected officials want a court that's going to defer to them and let them get away with what they want to do. And so what you tend to end up with is justices who tend to be more and more pro-government over time, I think. And, the GPS case is really just, as far as I can tell, it's just basically a replay or one more step past a decision we had in California about 10 years ago called People versus McKay that unfortunately was not really noticed by a lot of people. And this was a case where a person was arrested for riding his bicycle against traffic rather than with traffic. And this went up to the California Supreme Court, and Justice Janice Brown, who now is on the federal courts, at that time she was one of the justices on the state Supreme Court, and boy, do we miss her. She wrote the only dissent in that opinion, pointing out that in today's world, with so many administrative petty little offenses that you can be in trouble for violating. You can be arrested for violating any of these things under a Supreme Court case called Atwater versus Lago Visto. And once you're arrested, you can be searched incident to arrest, which means that because there are so many laws out there that you can't help violating somehow or another, the cops can just follow you around, wait for you to violate some minuscule little law, arrest you, search you, and there goes the Fourth Amendment, right?
Right.
Scary.
Well, in the context of that, thinking about it in the government versus individual dichotomy, and I think that Judge Kaczynski did a good job, at least, of recognizing that there was an economic issue involved in all this, that, the person in the California case was someone who lived in a trailer and had to park their car outside because they had no fancy garage with an elevator that takes you below ground and tightly locked down such that no device could be installed on their BMW. That's not the case for 99% of the people in the country, and that if you're not going to protect the curtilage, as we love to bring that word up on the show just because it's such a fun word, things that are in the curtilage of the home, then you leave a lot of people out in the cold simply because they cannot implement security measures that the very wealthy can.
Right, and this is just a specific example of a general point, which is that it's the poor or people who don't have a lot of political influence who need constitutional protection the most, because the rich or the politically influential, they can get the government officials to do what they want them to do, or they can take steps to prevent themselves from being harmed or whatever. But it's the people who don't have political influence who need the Constitution to protect them from elected officials or from abusive police departments or abusive mayors or whatever. And unfortunately, we tend not to hear about, or a lot of the time we tend to ignore, the complaints that this class of people brings against abuses by government officials. And so then the issue comes up, oh, well, you only care about the rights of some big wealthy corporation. That's because the big wealthy corporation was the only one that was able to make it to the Supreme Court of the United States. The poor man had to plea bargain, right? A great example of this is Skilling versus United States, a decision from last year, I believe. And that was a case over the question of vagueness. Criminal laws that are so vague no reasonable person can understand what they mean. There are statutes or common law theories. In the Skilling case, it was a statute that makes it illegal to deprive a person of the benefit of honest services, which nobody knows what that means. But there are also common law theories like public nuisance, which no competent lawyer can possibly tell you what a public nuisance is. It's such a vague term; it means anything and everything for the purposes of the moment. And either vague statutes or vague common law theories can be used, exploited by political actors to harm or violate the rights of anybody. But it tends to be the wealthy person who's able to challenge it in court. So you hear about that, and then people turn their backs and they say, oh, well, I don't care about the rights of evil Jeffrey Skilling who ran Enron. Well, sure, maybe Jeffrey Skilling was a bad guy, but what about the next guy who finds that the federal prosecutor shows up at his door and says, I'm going to prosecute you for violating a statute that you could not possibly have understood or predicted how it was going to be used or anything unless you sign this little document right here, right? That's what happens when courts fail to protect the rights of individuals under the Constitution.
So we talked about a case last week, Tim, that fits well into this rubric that I'd like to bring up again and just get your very scholarly and educated constitutional take on it. And that has to do with a Colorado woman who's being prosecuted in federal court. She's accused of a mortgage scam, and the Justice Department wants her to disclose her encryption passphrase for her laptop so that they can search the laptop and gather evidence against her. And she is asserting her Fifth Amendment rights, and also I think this implicates the Fourth Amendment of how far a government search can go. So we don't, know what's going to happen there, but I think it's an interesting sort of law school exam question kind of thought problem. What do you think about that in this government versus individual dichotomy we're talking about?
Well, I'm in the lucky position that it's been 10 years since I've had to take a law school exam. And since I don't specialize in criminal procedure, I would be hesitant to answer that question. Mm-hmm. I do think that it's a remarkable example of how modern technology is really pushing what have been for a long time the comfortable boundaries of precedent in regard to the Constitution. We over the course of decades developed interpretations of the amendments that made a lot of sense within the context of that particular technological world. And now we're finding that the things have changed so much that the courts are going to have to rethink how these work. And it's funny that a lot of the time you hear people say, oh, well, why should we care about the Constitution and the founders because that was 200 years ago and their world was so different from ours. We don't often hear the fact that actually the Constitution is written in basic principles that are applicable to all men and at all times. But the case law tends not to be. The case law tends to take a lot of assumptions from when the case law was written that really need to be rethought when technology changes.
All right, so we have one other search-related constitutional issue to discuss, and that is we just learned this week, or maybe it was late last week, that the constitutional challenge to these very high-definition airport body scanners has been rejected. I understand, though, that the images are going to be blurred. Any thoughts on this one, Tim?
Well, I'm of mixed emotions about these searches. On one hand, I think, first of all, I don't think there's any sense in the government being in charge of airport or airline security. I think that should be a matter dealt with by the airlines themselves. I think they have a better incentive. I think they would be better able to innovate. I think that they would be more accountable for their mistakes than a government that is generally immune from lawsuits. So that's one thing. The second thing is, when you find technology like these scanners, one thing that I think has to be kept in mind on the somewhat non-libertarian side is the more accurate the search technology, the better it is for civil liberties. It's better to be searched in a way that finds only particular things, particular contraband, than to be searched in just a general way. I would rather be searched with one of these body scanners that's looking just for a gun and really blurs out my face and doesn't produce an image that is, objectionable to me personally. I understand a lot of people have different views of that. I'd rather be searching that way than to have somebody just rummaging through my bag, right? Because what you want to eliminate is false positives and false negatives in searches. So there's something to be said for the idea that the better the technology, the more precise the technology, the better that is for the innocent person who's supposed to be protected by constitutional guarantees against suspicionless searches. However, I think that suspicionless searches are obviously what are going on here, and I think that we really should be skeptical of any attempt to get around the Constitution's boundaries against suspicionless searches. The excuse that's usually made in contexts like airports is border searches. They can search you at the border without a warrant. Well, the problem is, what do we mean by border? We found cases where the courts have allowed suspicionless, warrantless searches on the border theory miles and miles and miles and miles past the border because the person's been followed by the border patrol or whatever. And I think those kinds of cases or the precedent that have developed that way really need to be rethought.
Right. I hadn't really thought about the fact that, as you go through one of these body scanners, it is nice to know that if you're toting the gun, they're going to find that. But if you have your manifesto for overthrowing the government, that's going to remain safely put away somewhere because that's not what they're searching for.
Exactly. And I think one of the big problems, we tend to talk just about terrorism in the context of these searches, where in fact it's the terrorism subject that is the best argument for these searches. The problem is the use of this search technology or the use of the data that's discovered through these searches for things like the drug war or whatever, or you get put on a list somewhere and we don't know what happens to that list, and then that's used against you in some future proceeding. Those, in fact, I mentioned the David Shipler book that I recommended. He actually chronicles a lot of the way that data that's discovered through a terrorism search that is of dubious constitutionality to begin with can be used against you later to concoct or to support a charge against you for some completely unrelated offense. And that's a very serious concern, I think.
Yeah. Evan, any thoughts on these border or the airport scanning devices and the outcome here?
Not directly on what we're really talking about here, but I wanted to pick up on something that you said, Tim, about the incentives that the airlines would have to implement these security procedures rather than the government. I would be a little bit troubled by that, and perhaps we can come up with something that would maybe mitigate my concern a little bit here, is if we put this in the hands of private companies to do this security, doesn't that take this completely out of the rubric of the Fourth Amendment at all? And so then that we would, if we were to have to subject to these types of searches being conducted by a private entity as a condition to boarding an airplane, there would be no Fourth Amendment reasonableness at all in those types of searches. Is that something to be legitimately concerned about?
Oh, absolutely. In fact, it brings up a very good point, which is one of the exceptions to the warrant requirement is that the government is not required to get a warrant to get your information from a third party if you voluntarily gave it to that third party. And I think that exception alone is something that is going to have enormous impacts as we go forward technologically with, the Google, obviously. Every time I send an email through Gmail, that I'm surrendering information voluntarily to private entities who can then hand that information over to the government without my ever knowing about it, right, until the government shows up at my door. I think that is an extremely serious concern. And yes, if private airlines were to take over security, that would be one example of how that would affect people. But I think that is a problem that courts are going to have to deal with and come up with better rules for in the coming years.
Yeah, good.
All right, well, now that we've sort of exhausted the Fourth Amendment, let's move on to the First. I've been reading Tim's book this week. It's a wonderful book. It's called The Right to Earn a Living. Some very thoughtful discussions of economic freedom contained in here. And one of the most fascinating chapters has to do, it fascinated me anyway, as someone who thinks a lot about online communications, is the one having to do with speech and commercial speech. And how this plays out in the world of the web, and particularly new and multifaceted forms of social media. Way back in 2003, you mentioned Janice Rogers Brown earlier, Tim, and I was a huge fan of a comment that she made in her dissent to the Kasky versus Nike case, which you discuss at length in your book. Where she points out that the commercial speech doctrine in its current form fails to account for the realities of the modern world, a world in which personal, political, and commercial arenas no longer have sharply defined boundaries. And that is something that I think just keeps coming up again and again and again as corporations and individuals put themselves out on the web and discuss things. The Kasky case had to do with, well, why don't you, first of all, you can explain this better than I, Tim, tell folks who aren't familiar with it what happened in that case.
Well, that was a case where an activist who was claimed that Nike produced its shoes in third world sweatshops went out and made these statements and was complaining about it. And so Nike hired a person to go and do some investigation about their factories and write a report, and they then produced this report, published a report that exonerated them, or so they said. And when they produced this report, this activist, Mark Kasky, sued Nike, arguing that this was an unfair business practice under California's Unfair Business Practices Law, also known as Section 17200, which makes it illegal to engage in unfair business practices and defines that as any business practice that is unfair. It's that vague. Nobody really knows what an unfair business practice is in California. It basically means anything you do that liberals don't like. So Mr. Kasky sued Nike for expressing itself on a matter of political importance on the grounds that doing so is an unfair business practice, and won. Nike argued that this was protected by the First Amendment, but the California Supreme Court rejected that argument, saying that instead the commercial speech doctrine test applied instead of the regular First Amendment test, because Nike produced this report in the hopes of influencing consumer choices. And of course, under the commercial speech doctrine, speech gets a lot less protection. So now the problem with that, of course, is that everything a corporation ever says is intended in some way to influence what consumers do. And so the California Supreme Court decision radically undermined the right of businesses, or the right of people who do business in the form of a corporation, to protect themselves or to express themselves on matters of political importance. And unfortunately, although the U.S. Supreme Court took that case, it then later dismissed it for procedural reasons. No, they settled it. That's right. Nike ended up settling that case before the Supreme Court decided the issue. So we're still kind of left with some vagueness, although there was a decision this term that seemed to strongly support the right of businesses to express themselves. So I'm hopeful that the courts will take this First Amendment issue more seriously in coming years. Businesses play an important role in American democracy in discussions over public policy. Corporations ought to be able to express their side of a political dispute, especially since so many political disputes involve corporations. We should be allowed to hear what Nike has to say about a political debate that involves the future of Nike. But unfortunately, because of the commercial speech doctrine, these businesses get a lot less constitutional protection for their right to express themselves.
Right. We met at a conference about blogging and the law around blogging. And just this week on Google+, we've seen this strange tension between having an individual account, which is what Google wants those accounts to be for the time being as they develop and roll out their business account strategy, and the fact that there are these many brands that have jumped in, Mashable being one, etc., and have established accounts in violation or counter to Google's wishes for their business. But now, in order to sort of balance that, Pete Cashmore of Mashable is blogging as himself under the Mashable account, sort of a placeholder, I guess, until these accounts get established. But where I'm sort of going with this is that I think it's really hard to draw that line.
Oh, yeah. And
are you speaking as an individual, or are you speaking for your brand?
It's going to become increasingly complicated because the internet in particular allows people to become their own brand. And mm-hmm. you basically become your business. My profession is being Tim Sandefur or whatever. And so you see over and over, you see these websites that are the person's name, and what that person does is produce a particular, very personalized product or service, or maybe they're a public speaker, or they're a writer or something like that. How do you draw that line? You can't draw that line, but productive activity is part of our personalities, and expression, personal expression, also can't really be divided from commercial choice. A lot of people feel that their personalities are expressed by their commercial choices. I live in Northern California. If you see a Volvo on the freeway, you know how that person votes. Simple as that, right? Our products, the products and services that we choose to buy, say a lot about ourselves, and in a lot of the time, that's why we choose to buy that product or service. So drawing a line between mere vulgar commercial activity that's not deserving of any constitutional protection and honorable self-expression that deserves the highest form of judicial solicitude, I think that kind of thing that's a really super simplistic way of looking at human behavior and the Constitution.
So in the Caskey case, let's use that as an example. Nike was not able to assert the First Amendment to block these unfair competition and false advertising claims. So that just meant that they had to defend against those claims. It doesn't mean that they would be held liable for those.
Oh, no, that's not correct. They would
be. Correct
yes, me. They were being sued for unfair competition. They were not being sued for expression per se. They were being sued on the grounds that it was basically false advertising, is what the plaintiff claimed. Mm-hmm. And so they were actually being sued for damages, for liability, for having expressed themselves in a way that the plaintiff considered to be unfair.
Mm-hmm.
So it wasn't just a question of an injunction or anything like that. It was a question over whether Nike had engaged in an illegal activity by expressing itself. And this is related to another realm where we see the rights of businesses to express themselves concerned, and that is where you see government confiscating words and prohibiting anybody from using those words without a government license. I'm working on a case right now in the California Court of Appeal where the government has confiscated the word pesticide, and what they say is you're not allowed to express that your product or service repels or kills insects or pests, even indirectly, without getting government permission. So my client produces a fertilizer that's it's made of worm poop, called worm castings, to be more polite. He produces this fertilizer called worm gold, and what it does is it strengthens plants and makes those plants produce chemicals that smell bad to bugs. It produces an enzyme that bugs don't like, and so the bugs avoid the plant. So he truthfully advertised that his product could help you keep bugs away from your plants. Well, California claims, therefore he claimed it was a pesticide, and therefore he has to be fined $100,000. So here's a case of where you're not allowed to truthfully advertise how your product works without getting government permission. I think that's unconstitutional.
Right. But I guess what I was trying to get at there is that it's one thing to say you cannot be sued. It's another thing to say that you can be sued, but you have a defense to that suit. You know what I'm saying? So
I can see your point. And we saw in the recent case about Fred Phelps, we saw a case where there was a tort lawsuit for infliction of emotional distress, and the defense was, well, we have the right to express ourselves at these funerals, and the court held that was the case, that you couldn't use the tort claim in a way that would infringe on the First Amendment protected rights, which is basically like the argument in cases like New York Times versus Sullivan, where there was a lawsuit for slander, and the Supreme Court said you can't use slander laws to infringe on a person's freedom of speech. And what I'm saying is that the same rationale should apply when the speech at issue is about a commercial transaction.
Right. Evan, what do you think about the state of the commercial speech doctrine?
Well, it's fascinating, and I'm wondering what makes it so unique to us today. Getting back down, kind of focusing a little bit closer to the individual level, none of us are Nike Corporation and having the same kind of concerns that Nike would have, but when we're looking at us as pajama-wearing bloggers and users of social media and all that stuff, going out there expressing ourselves, promoting a personal brand or what have you, I'm wondering what it is that makes it such a poignant issue today, and why it's different, why the analysis would have been different back in the good old days whenever the commercial speech doctrine was apparently subject to clear delineation. Were people so different back then? Did not people, was there not the equivalent back in the 20th century of people driving a Volvo as if to express their political, making that commercial statement to otherwise express something, about themselves? And I'm not necessarily suggesting that there is a clear answer to this. I guess this is a quasi-rhetorical question that I'm asking. But if we're going to try to keep the commercial speech doctrine and that distinction in place rather than throwing it out, what is it? Where can we meaningfully draw that line? And is it something that's endemic to the way that things are today, the norms that we have, and the modes of communication that we have? That's what I query in all of this stuff.
What do you think, Tim?
Well, I think as a sociological matter, I do think that in recent decades we've tended to see people express themselves in a commercial fashion more. The reason why Andy Warhol was such an important artistic voice in the mid-20th century was because he caught on to the way people were increasingly using mass production to express their own personalities. Take T-shirts, for example. I mean, people only started wearing T-shirts in public at the end of World War II. And then people started putting things on T-shirts, and I remember when the technology for putting things on T-shirts was so bad that you could wear a T-shirt maybe once and wash it, and then it was ruined. So only in the past several decades have we even seen the capability of expressing yourself by adopting commercial logos and things like that as much as we've seen. I do think it's always happened to some degree. I mean, boycotts are all about using commerce to express ourselves. But the other added factor is that the Supreme Court basically just completely rejected the idea that commercial advertising was a form of expression in the 1940s in a case called Valentine versus Christensen, where the court doesn't appear to have even really seriously considered the question. But of course, at that time, the court also said that movies were not protected by the First Amendment because they were simply a commercial product, which is an astonishing holding that nobody would ever have agreed today. But that was the Supreme Court doctrine at the time. So on one hand, we've seen more liberalization from the court, and on the other hand, we've seen an increasing tendency for sociological and economic reasons to express ourselves with commercial choices.
Right. That's why this seems to me an issue to watch and pay attention to, because things that people write on the web seem much more akin to me to a movie, a creative and protectable speech-laden work, than to an advertisement, although there certainly is a commercial overtone to a lot of the speech, and it's done, to garner goodwill and etc. So I don't know. I think it's a hard issue and one that I think the courts need to pay attention to as technology evolves. I think that this is one of those instances where technology really does make a difference.
And it's impossible to say which direction that's going to go for sure, but I do think that on the whole what we're going to find is that it is no longer tenable to draw some sort of conceptual distinction between commercial activity and other kinds of expression, and that the decades-old prejudice against businesses that we have seen in the courts since the New Deal, I think that's going to have to be abandoned, and courts are going to have to start taking seriously the right to earn a living.
There we go. Well, we're going to talk about more issues on the right to earn a living, including bandwidth caps and taxes and licenses, right after this break, where we're going to thank our sponsor, Netflix. Netflix is bringing you this show today, episode 121 of This Week in Law. It streams thousands of TV episodes and movies directly to you instantly, which means you save time, money, and hassle. There are several easy ways to instantly access streaming movies and TV shows with Netflix. You can watch Netflix movies and TV shows on your Mac or PC or iPad. The iPad app is really convenient. You can watch on your iPhone and some Android phones too. If you have a gaming console, an Xbox 360, PS3, or Nintendo Wii, you can watch right on your TV. And if you're not a gamer, you can watch Netflix on your TV with an Apple TV box, a Roku box, or many, many DVD players have a Netflix add-on built right in. If you're not a gamer, you can watch Netflix. Oh, that's what I just said. Sorry about that. With Netflix, you can watch movies and TV shows instantly using any of these devices. And you can begin watching a movie or show on one device and finish it on a different one. That is extraordinarily convenient and acknowledges the way that we wander around in the world today, from device to device, room to room. Whichever way you choose to watch Netflix, you can watch as many movies and TV shows as you want, anytime you want, and you can cancel anytime. So if you're not already a customer, do go over to netflix.com/twit. Be sure to use this URL when you sign up for your free trial. You can get it 30 days absolutely free by going to netflix.com/twit. We thank Netflix for their support of Twit and This Week in Law, and we hope you enjoy watching instantly with Netflix. Now that was some commercial speech for you there, folks. All right. So let's talk about some of the other points that I think we can weave into the analyses in your book, Tim. We've been talking on the show recently, and folks have been paying attention to the fact that because of services like Netflix, who we just thanked, there's a whole lot of bandwidth usage going on that I think the ISPs may not have anticipated a few years ago, and bandwidth caps are either being enforced or imposed. There's an article this week about how long Sprint can keep its unlimited plans in place, since it seems to be becoming the haven for people who are bandwidth hogs. And I think that this is a real interesting doorway into this concept of a right to earn a living. You know, for people, again, we're talking about not the big corporations, but people who perhaps work out of their home and are buying whatever internet service that they can get to be able to do that, and then they're getting capped. I think that, that begins to impinge upon the right to earn a living. Of course, we're talking about private actors here and not the government. But let's just put this on the table, and I'd like to see if you think that bandwidth caps begin to implicate constitutional concerns at all.
No, I don't.
Okay.
For one thing, I think that internet service providers themselves, of course, also have the right to earn a living, and that means the right to set their contracts as they choose. And if they have stated in a contract that we're only going to give you X amount of some service or product, then they have the right to enforce that. And of course, they have the right to renegotiate a contract afterwards. And that is the price of doing business, because we have to respect the rights of suppliers as well as demanders in the market. So, no, I don't think that raises constitutional concerns as long as the government doesn't get involved. I think it would be a concern if we see, and we've seen things kind of like this in the past, where there are proposals to force businesses to provide certain kinds of service or certain amounts of service. And I think that would be a serious concern, because this stuff isn't free. Nothing is free. And we cannot just simply legislate that something be provided and expect that it just magically appears out of nowhere. Somebody has to produce this product or service. And no matter what the product or service is, if it's internet service, if it's healthcare, if you mandate that it be provided, you're saying that one person has to work and give up the fruits of his labor to another person. And that simply is unjust.
So the point that comes up a lot in the context of this discussion is whether or not there's an inherent right to internet access, whether an ISP should be treated like a utility, that these are equivalent to your power and your water and all those things that we're going to say that perhaps are provided by public companies, but if they're going to cut them off, there better be a good reason. I think you may have just answered the question I have around this, which is, do you think there's an inherent right of internet access, and why or why not? How does that play out?
No, absolutely not. You have no right to a product or service provided by another person under any circumstances. You have the right to be left alone, and you have the right to the fruits of your labor. But for me to say that I have the right to internet access, or the right to healthcare, or the right to transportation, or the right to food, would mean that nature is inherently violating my rights every day of my life, because nature doesn't provide me with products or services that I want. And that is an incoherent concept of rights. I would encourage anybody who wants a more lengthy explanation of the concept of rights to look up a new book published by my friend Tom Palmer called Realizing Freedom, that has a wonderful explanation of the meaning of rights, and particularly the idea of compossibility. And that is, for a right to be a valid right, it has to not conflict with the rights of others. And yet to have a positive right to a product or service inherently conflicts with the rights of others. If I have a right to health care, for example, the Universal Declaration of Human Rights published by the United Nations also says that people have a right to paid vacation, a fundamental human right to paid vacation. What if my doctor's on vacation? My right to health care conflicts with his right to a vacation, and they're therefore incoherent. Whereas natural rights, what are sometimes called negative rights, my right to be left alone, conflicts with nobody else's rights. I can be left alone, and so can you, and those two do not conflict. So the problem, a large problem, if not the major problem in all American politics, is our tendency to define right as something I really want. You don't have a right to something you really want. You don't even have a right to something you need. You have a right to what you produce, and you have the right to what you can freely and voluntarily exchange with others.
Right, and we do see free market competition playing out here. In that article I mentioned about Sprint, there is a provider out there who's offering the service without caps and trying to distinguish themselves that way, at least for the time being. We'll see how it plays out.
Well, let me add to that the argument about public utilities, because utilities is a more complicated question. What you find in the history of the law is that utility was tended to the idea of a public utility evolved out of common law theories about corporations themselves at a time when corporations were basically government entities. They were quasi-government entities chartered by the king to accomplish a good or a particular goal. And they enjoyed certain government privileges. For example, it was illegal to compete with them, or they enjoyed the power of eminent domain. And as a result, because they had these government privileges, therefore government had the authority to impose certain restrictions on them and say, in exchange, for instance, railroads, in exchange for using eminent domain, you also have to promise to take anybody who wants to come on the train, or have your rates regulated by a board or agency. And that's where the public utility comes from. And so the idea of natural monopolies and that sort of thing. I don't know how that works out in the internet context, but I very much doubt that the arguments for seeing internet service providers as public utilities are anywhere near as persuasive as they were in the case of railroads.
Evan, what do you think?
Well, Tim, you do a great job in laying all this out, and it really resonates with me the way you're talking about it in terms of these rights being coherent or incoherent with one another. And I share in your sentiment that the ISPs have the right to make a living as well, and that nobody has the rights to receive the fruit of another person's labor. In a lot of people's mind, I imagine that, and I can kind of empathize with a contrarian position here to what I've just set out. I mean, I think this is a little bit complicated when we're talking about this so-called right to internet access, and even to be so grandiose as to say that it's a human right, because it's complicated, and depending on how we want to characterize it, we could characterize it either as a certain right to be left alone, or a certain right to the services of another. And here's what I mean. At a certain point, the access to the internet becomes conflated, almost tantamount to the very essence of the ability to communicate. That's the only way we have to talk these days, perhaps. It's not going to do much good to go out and just shout something on the street corner. You've got to be able to tweet it, or, put it on Facebook or whatever, right? Update your blog, whatever. So, it can be characterized in a certain way by saying that if I don't have this access, then I am not being left alone. I'm actually being invaded upon by saying, my right to speak is not being left alone. It's actually being shelved or somehow freighted with some kind of obstacle in the way. But I think we're really not at that point yet, because it's just perhaps not that essential to us. And I would hope that there would be more coherent ways of articulating it that would kind of recounter against the countervailing position that I was talking about, right there. As of now, this is to reiterate something I said on last week's show, I just don't have much sympathy for particular instances where people have gotten kicked off the internet for excessive use because their use is so excessive. I mean, they truly are bandwidth hogs, using orders of magnitude more bandwidth than the average person. And then it brings into question larger issues of ethics. What is the right way to conduct oneself when, by definition, a network is something that's cooperative and collaborative, and we all have this responsibility to use resources and be stewards of those resources in a certain way. So it gets nuanced when things start to converge, like the access and the right to speak and responsibility. There's a lot of stuff going on on this issue for sure.
Right. A couple of observations, one from our IRC. And if you do watch us live when we record at 11 Pacific time, 1800 UTC on Fridays, you can join the IRC at irc.twit.tv. Beatmaster in there is saying, pointing out that European countries tend to own their main telecom, and with that, the infrastructure. So this is mainly a U.S. problem. And my own thought as we're talking through this is that part of the issues these ISPs are facing and why they're coming up against so much protest and outcry as they're imposing or enforcing these bandwidth caps is maybe they've been there all along in the fine print of the documentation, but they're certainly not very well advertised when you're signing up. And, I've definitely seen people doing information graphics and pointing out that the disclosure on all this stuff is low to none, unless you're willing to dive in and read that fine print, which of course, nobody does. So that's not usually an excuse, and the fine print is probably a complete defense to the inevitable false advertising or unfair business practices kind of lawsuit that might come of this. But it still, I think, strikes people as unfair. Any thoughts on that, Tim?
Well, I sympathize with that. I've been sometimes caught by things I didn't see in the fine print either. I can't tell you how shocked I was just earlier this year when Gmail told me I had to buy some extra space. It had never occurred to me that I might actually fill up my Gmail archive.
You Gmail hog, you.
Exactly, and it's my responsibility to read the fine print, and if I didn't, then that's my fault. So, of course, there are cases where fine print is so fine as to be fraudulent, but I think that at bottom, it's the consumer that protects the consumer, and if an ISP is providing bad services, then consumers will find that out from the complaints of other consumers, and they will suffer for that. I mean, we've seen businesses that everybody thinks are these giant monuments of industry that will never go away evaporate. The most obvious recent example is Borders. I remember when Reason magazine covered on their cover a story about how small mom-and-pop bookstores were complaining that Borders would someday destroy them, and now it's Borders that's being destroyed. So what you see is the dynamic effects of the marketplace actually are a lot stronger than most people tend to agree. Now, I would disagree with Evan's point about how I have a right to internet access because I would be a more effective speaker if I had it. It's true, of course, that a person who has a lot of media resources at his disposal will express himself more broadly than I will standing on my soapbox, but that does not mean that I have a right to any share of those media resources. I have the right to express myself and not be interfered with, and I have the right to whatever I buy, so I have the right to a commercial if I buy it. But I have no right to force other people to provide me with media resources just because I would be a more effective spokesman for that. The theory behind that supports that proposition would be I have a right to whatever will make me happier or make me more fulfilled, or a right to access something that I want or need by some abstract rubric that is kind of vague to me. And on that theory, I would then have the right to the whole world because, of course, I could be an even more effective spokesman if I owned California as my own personal property or what have you. And there's no clear guidelines to cut off reasonable from unreasonable claims if we assume that you have a right to resources that would make you more effective or more happy or more fulfilled in that sense. The natural rights proposition that I have a right to my own resources and those that I freely exchange with others is the only operable, sensible, logical proposition for moral rights. And again, for a more thorough explanation of this rather complicated subject, I would refer you to Tom Palmer's book.
Maybe all we need to say is that everybody has the right to be Rupert Murdoch whenever they want to be, and that'll solve it all. There's an effective communicator.
Ouch.
But the most important point of that is that Rupert Murdoch has the right to be Rupert Murdoch.
Bless his heart.
I'm hoping that right doesn't get exercised too frequently. One right that the states have been attempting to exercise vis-a-vis Amazon lately is their right to collect sales tax. And Amazon, as we've discussed before on the show, has traditionally refused to collect sales taxes on its transactions for any states where it doesn't have a physical presence. And some states are taking umbrage with that, and Amazon is fighting back by cutting off affiliate programs in those states. And I'm wondering, Tim, if you've taken a look at this whole conundrum and if you have thoughts on it.
I've only looked at it very briefly because I was one of those Amazon affiliates who was cut off. I received an email from Amazon, which I posted on my blog, congratulating Amazon and thanking them for standing up for the rights of wealth creators in California, even if it came at my own personal expense. I wish that we would see businesses more willing to stand up for their rights. What we tend to find instead is corporations bending over and taking it and letting government do whatever it wants with them and saying, please serve me, I have another. So I congratulate Amazon for having the will to stand up and say, we think this is wrong and we're going to protest it and take action. I wish that more wealth creators would do that.
Right. It seems per this statistic I'm seeing from the University of Tennessee in the Business Insider article I'm going to put in our show notes at delicious.com/thisweekinlaw/121. They estimate that states are losing out on $11.4 billion in sales taxes due to this situation. Evan, anything you want to add here?
No, just I guess I miss that slight revenue that I would pull in once in a while.
couple of bucks.
Right.
Let me say that in defense of California, far be it from me, but in defense of the states that are taxing these businesses, the prohibition on internet taxes was originally devised as a sort of subsidy to encourage internet businesses, and it does seem that there's a legitimate argument that brick and mortar businesses have to pay these taxes and don't get that same kind of subsidy. And it's not a fair deal then to say that we're going to keep this in place in order to encourage internet sales when they're doing pretty well now. They're up off their feet. We don't have to worry about that, right?
Right,
so
and
I do
Borders
think there
is
an
gone.
argument. Yeah, and I do think there's an argument to be made for that position. However, I am on principle just opposed to taxes and to government taking property from people in order to fund programs that pay people not to work. So I'm all for Amazon on this one.
Okay, so this is a related topic. Let's talk about the Louisiana monks and their coffin building enterprise, and how they you have much in your book, Tim, about licensing schemes that strangle businesses, and this is one of those instances. Except for here, the monks seem to have prevailed.
Yes, this was a decision that came down yesterday from the Louisiana Federal Trial Court, striking down a Louisiana law that limited the sale of coffins and required a license to sell coffins. And it's kind of odd that we see economic liberty issues of this magnitude being litigated in the realm of dead people so often. This is the third, or possibly the fourth, economic liberty case in recent years to involve the sale of coffins or similar. The first one was a case called Craig Miles in Tennessee about 10 years ago, where the Tennessee law prohibited the sale of coffins unless you were a licensed funeral director, which required 2 years of training and tens of thousands of dollars in education, learning skills like embalming bodies and things that you would never do. All you're doing is selling a coffin. Nevertheless, the state created this monopoly on coffin sales for the sole purpose of protecting the income of established businesses against fair competition from outsiders. And the Sixth Circuit Court of Appeals held that this was unconstitutional and that government may not use its licensing laws simply to protect established businesses. Very soon after that, however, the Tenth Circuit, in another coffin case, or maybe it was a urn case, upheld a very similar law, saying that government can use its licensing laws solely to protect established businesses against fair competition, even if the law has no connection whatsoever to protecting the public health, safety, and welfare, which is a very extreme proposition. It's really a remarkable idea that the government can prohibit businesses in order to protect other businesses with no connection to protecting the public health or safety or at all. And so the new case has rejected that Tenth Circuit view. This is a case in the Fifth Circuit in Louisiana that has held that government may not use its licensing laws in these unfair ways. Licensing, is a very important matter. It's something that restricts freedom of economic opportunity for the hardworking entrepreneurs who generate the wealth that we all live on. And it often does so not to protect the public, but just to help insiders. The first case to uphold the constitutionality of licensing laws is a case called Dent versus West Virginia in the 1880s, written by my hero, Supreme Court Justice Stephen Field. And it said, government can use licensing to protect the public, but not if it's going to have no relationship to the skill or the trade that the person is performing. But unfortunately, what we've seen is since the 1930s, courts have backed away from that proposition and allowed government to limit entry into certain trades or professions simply at will. And of course, lobbyists from these industries go and get these laws passed in order to reduce competition and raise their own prices. So it's very refreshing to see this decision from Louisiana, and I'm hoping that it will lead to a victory at the Fifth Circuit and eventually to a Supreme Court decision saying that, government can use licensing laws to protect the public, but not to protect the private interest of politically influential groups.
So the internet tie-in here, I guess, is that Louisiana was attempting to either bar or require licenses of out-of-state casket manufacturers who were attempting to make online sales in the state. Do I have that right?
And there's a similar thing in the Oklahoma case, in the Tenth Circuit case, where it was internet sales of coffins and funeral urns. And it's interesting because this is another example of what I was saying earlier about how the case law has developed with certain technological assumptions in mind that are no longer valid because of the internet. So maybe 50 years ago you can see that, well, they'd pass a law that says, well, if you're going to sell an urn, you have to be a licensed funeral director. And although I would think that too would be an invalid law, nevertheless, you can see why they would say, well, it won't affect that many people because the only people who are going to sell urns are Oklahomans who practice the trade of funeral directors. But now with the internet, you can buy funeral merchandise or other merchandise from anywhere around the country, and it no longer really makes any sense to say that the state has to limit these kinds of sales. Now, another point is that these licensing laws often occur, or these licensing cases rather, often come about because somebody has found a way of practicing one small part of what is generally thought of as a larger trade. So, for instance, I won a case in the Ninth Circuit involving pest control workers, and my client, all he did was put spikes on buildings to keep pigeons and other birds from landing on those buildings. And he was required by California law to get a license as a pest control technician, which required him to get training in learning how to use pesticides, how to deal with insects, all this stuff that he doesn't do. He only did this one small section of the trade. And we succeeded in having that law struck down as unconstitutional. So here's an example of how what's going on is the innovation, largely made possible by the internet, of being able to practice one small fraction of what is generally thought of as a larger trade, is going to make these licensing laws make no sense. Another case example is hair braiding. We've seen a lot of cases involving licensing of people who practice a trade of traditional African hair braiding. Well, under the laws of a lot of states, they're required to have barber licenses, even though they aren't barbers. They're only practicing hair braiding. They're not cutting hair. They're not doing hairstyling of any sort. They're just braiding. Well, we've seen a lot of victories in these cases precisely because the licensing laws that decades ago, maybe it made sense to say, well, we're going to treat hair care as a single trade. It no longer makes sense to think in those terms because we're finding new businesses coming up to practice one small fraction of a trade, and the internet is making that more common.
Evan, do you think that the internet's driving innovation in scaling back state licensing schemes?
Sure. I mean, you can't help but think about what effect this could have on the practice of law and some of the automations, some of the innovations that you would see with things like contract drafting and trademark filings and some of the rote things that really, you got to admit, you don't need the expertise of a JD behind you to do all that stuff. And this seems something that would fit naturally into a theory if you're going around looking at the world in terms of the long tail theory, little slices of things, little very niche places where goods and services are being provided. It seems like, in any industry, it's something that would run the risk of this immensely small, I guess, specialization, giving rise to the possibility that you're going to be an outlier in what would erstwhile be a certain set of a trade. This is really a great point.
The internet really makes it so that niche businesses can survive in ways that they couldn't in the past.
Yes. Right, because there's less of a resistance between the person with the demand and the person who has the supply for it. My 5-year-old has a loose tooth. Well, guess what? You can go on Etsy and find at least 20 different people who are selling special little pillows to leave out for the tooth fairy. You don't just walk down to the street and do that. It's not going to be something of the tapestry industry or whatever like that. But talk about specialization, and it's just smaller and smaller, more and more, getting smaller and smaller.
Maybe they'll have to be licensed in the dental field to be able to provide those sorts of services.
We need to protect the dentists and the orthodontists, that's for sure, because this is obviously an issue of public safety and health about how the tooth should be kept after it dislodges from one's mouth.
And you and I can laugh about that. Unfortunately, because of the case law that exists, that sort of thing would pass muster, no question, because the rational basis test that courts use to assess the constitutionality of licensing laws and other restrictions on economic freedom, well, there's no question it would uphold such a law. And that's the real problem that we have when it comes to economic liberty in the courtroom, is that courts have for decades used this anything goes rational basis theory to allow government to restrict economic liberty in the most absurd and unfair ways. And obviously I hope that that's going to change over time. And we're seeing some signs of that. I think this Louisiana decision and some other decisions that we've seen recently give good reason to hope that the courts are going to start making rational basis a little more rational, rather than just sort of a rubber stamp on whatever the legislature decides to do to entrepreneurs.
Sure.
Do you think that the legislature itself, the legislatures in our states and at the federal level, might begin to slice and dice things a little more finely and say, yes, we want lawyers and doctors and pharmacists to have licenses, but cabbies and tooth fairy pillow manufacturers go forth and prosper?
Well, it's hard to answer that question specifically, but I think generally speaking, we are seeing state legislatures taking economic liberty more seriously. Right now, I'm working on a case. I wrote about this in the current issue of Regulation Magazine that you can get on Cato's website. I'm working on a case in Missouri where my client runs a moving business, and if you want to run a moving business in Missouri, you first have to get permission from all of the existing moving businesses. Surprise, surprise, they're not willing to give you permission. So we challenged the constitutionality of this law, and the legislature backed down and voted overwhelmingly to repeal this licensing restriction. Unfortunately, the governor vetoed it 2 weeks ago, and so our lawsuit is going to have to proceed. But I think it's a very healthy sign that we're seeing state legislatures take economic liberty and questions like licensing a lot more seriously. And why not? I mean, this isn't, like we were saying at the very outset about privacy rights, this is not something that should be a partisan Republican versus Democrat issue. Licensing is overwhelmingly used in this country to restrict economic opportunity for those who need it most, and to benefit those who have the most political influence and wealth. And to have courts be more skeptical of such laws and protect the rights of entrepreneurs benefits us all. It shouldn't be a partisan issue. It should be something that we take seriously as a constitutional matter, because the Constitution protects our liberty. It protects liberty in general. It doesn't protect specific liberties. It protects liberty in general, including the right to earn an honest living.
But, we can tie this back to something we were talking about earlier, and I'm using my own words to summarize this, the importance of corporations being heard. Nike, should have, maybe we could conclude that Nike should have been heard in all of this. When we're going to be talking about this certain rational sense that the courts should apply, or the ways that the laws should be enacted and what the legislatures are going to do. I mean, they're going to be the legislature, not the courts, hopefully, but the legislature is going to be subject to special interest and lobbying and stuff like that. Do you see a certain tension here between the interests in this corporate speech and the kind of the doing away with this lesser protection for commercial speech and this interest that really not to invoke Reaganomics, but this interest that kind of trickles down to the consumer, or at least the small business person wanting to get in, getting over this barrier of entry into the marketplace? Is there a tension there?
There is a tension, but there's a solution to that tension, and that is to have a principle in place that the government does not hand out these economic favors. Of course, businesses are going to ask for economic favors. They always have, and they always will. Adam Smith has that famous passage about how businessmen can never get together that they don't come up with some scheme for setting prices or whatever. People tend to forget that the second sentence right after that, Adam Smith says, "But we can't do anything about this without violating the right to liberty." We have to make sure that the government doesn't create these kinds of barriers to entry or hand out favors to these private interests, and respects the rights of everybody. The solution isn't to strangle lobbying by corporations, as the Federalist Papers says. You could solve the problem of faction by prohibiting freedom of speech, but that would be worse than the disease. What we need instead is a government that is limited in its powers, that is restricted by the Constitution to engaging only in public affairs and not choosing winners and losers in the marketplace, or restricting entry to entrepreneurs in such irrational ways as requiring somebody to spend 2 years learning how to embalm bodies in order to sell a coffin, or requiring a person to spend 2 years learning how to poison insects in order to install spikes on a building to keep pigeons away. I mean, we're finding courts often turning a blind eye to the most crazy licensing restrictions and other limits on economic freedom. What we ought to have is liberty for all. I know that sounds like a sort of a dream, but I admit I'm a dreamer, and just like the song says, I hope that someday you'll join me.
I guess you're not the only one.
I want to talk about licensing in a different context. We're talking about the Constitution and things that are provided under it. Our entire intellectual property regime in this country flows from our Constitution. And it, too, hands some protectionism to folks for limited times. So it says in the Constitution. And I'm wondering, Tim, against the backdrop of what we've been discussing here and your book on economic freedom, what you think in particular of copyright and the status of copyright today and efforts to reform it.
Well, unlike a lot of my friend libertarians, I view intellectual property not as a natural right at all, but solely as a government-created privilege, a monopoly that's handed out to address what is often perceived as a market failure. Whether they're effective in doing that or not, whether they actually spur the kind of innovation that they're claimed to do, I think is a matter for a lot of debate. And I think there's good reason to doubt that patents and copyrights really encourage the kind of innovation that they're said to encourage. I think a lot greater concern is the way that they stifle innovation, the way that they violate individual freedom. Patents, for example, and I used this in a paper that I wrote some years ago about Ayn Rand's theory of copyright. She believed that copyright was a natural right, and I reject that argument. And one reason why is my mother, about 20 or 30 years ago, invented an idea. Her idea was to put a paintbrush. Imagine having a wedge at the end of a paintbrush, like a screwdriver, right? That way you could pry up a can of paint with the paintbrush without having to go get a screwdriver. Great little idea, right? She came up with it entirely by herself. It wasn't something she stole from anybody. Well, it turns out it's already been patented years ago. If she were to go into production, manufacturing, and selling her paintbrush paint can opener thing, she would be in violation of the law and could be sued and subject to treble damages. Well, that violates her rights. That initiates force against her when she has done nothing immoral or unjust or anything like that. So I have real problems with the idea of copyrights and patents as a moral matter, as well as whether they actually accomplish the good of spurring innovation that they're said to spur.
So since we don't seem to be having a whole lot of success in actually reforming copyright and patent law, although there is the first most comprehensive patent reform bill pending right now that we've had in a long time, and we were going to have Matt Buchanan on today to discuss that. Hopefully we can bring him on shortly to have us brought up to speed there. But in the meantime, since the reform movements are slow and somewhat tortured, we do have, here we go, a little graphic from Mimi and Eunice here, and talking about how...
Did you get permission to air that?
It's licensed.
All right, okay.
We know the artist. The art I want to make is illegal, and hold on while I go reform the law, and the poor little guy is left with cobwebs all over him after the lengthy time that's taken. So in the meantime, we have Creative Commons out there that is sort of a workaround for copyright reform, giving people an option to license their works in ways that might not otherwise be easy or available. And I just wanted to highlight that Creative Commons is almost 10 years old now. They've written a little ebook called The Power of Open. I guess it's also a Lulu book if you want to purchase it in hard copy form, with some interesting thoughts and statistics about what's gone on in the nearly 10 years it's been around. Over 400 million Creative Commons licensed works are out there now. And I wonder, Tim, do you think that this is sort of, what do you think about having to come up with this stopgap or workaround?
It's a shame that people have to come up with things like that, but I think it's a great example of how there was an old saying I remember some years ago that the internet interprets censorship as a bandwidth problem and routes around it. And I think this is kind of the same is true of markets in general. You'll often find that there's just if there's an incentive, if there's a will, there's a way. life finds a way and that sort of thing. I think that's fine. But unfortunately, it means that people who are disposed to abuse, or maybe abuse isn't the right word, disposed to use the copyright or patent laws in ways that restrict freedom, they're still able to do so. It certainly is not a solution to the major problem. Let me give you an example. Some years ago, I blog, in addition to my own blog, I blog at Panda's Thumb, which is a weblog that covers evolution and creationism disputes. And so I'm connected with some scientist friends of mine who write about evolution. And a creationist schmuck named Casey Luskin, I guess I can call him a schmuck, threatened this scientist with a lawsuit for posting a photograph of him on his website, along with an article criticizing Luskin's creationist views. Now, his lawsuit threat was because I own the copyright to this photograph. Now, that's a great example of how the copyright laws can be abused in ways that, the scientist, he probably would win the lawsuit if there was a lawsuit, almost certainly, but it threatens people. It's a way of using the copyright laws as a hammer against people, and that's hardly the only example of how the copyright laws can be used to censor criticism or stifle discussion in the marketplace. So I think that Creative Commons is a great idea, but it does not solve the real crucial underlying problem, which is the restriction on individual freedom that comes from these copyright and patent privileges.
And we want to thank Nina Paley for letting us display her graphic of her great strip, Mimi and Eunice, and for all the wonderful art she does under very nice, lenient licensing terms. Evan, any thoughts on any of the copyright IP discussion?
Well, I'm, of course, a big fan of Creative Commons. I have been for years, and I certainly hear what Tim is saying. And, that doesn't cause me to lose any faith in Creative Commons or think that it's a thing that is not critically important to, the more liberal use of works and the availability of stuff to go out and remix and to foster and have this remix culture flourish. Given the fact that we've had problems of fighting two wars and financial crisis and most recently worrying about the debt ceiling and stuff like this. Clearly, the type of reform in patent and copyright law hasn't been in the consciousness of Congress as much as we would have liked to have been. So I'm glad to see that something like Creative Commons comes along and complements the system in a way that brings out some of the good attributes that we would implement into a reformed copyright system if indeed we had the unhurried opportunity to rewrite the Copyright Act. So when you look at this graph, which is in this ebook that the Creative Commons organization released, the power of open, it's just amazing to see the accelerated pace of adoption of Creative Commons. Back in 2000. We were talking about 2006 era a little while ago. It looks like maybe around 50 million works were available then. Now it's almost up to 500 million works, which, interestingly enough, is about 250 million less than the number of people that there are registered to use Facebook. So we've got to keep all this in perspective. But I'm encouraged to see the uptick or the grand adoption of Creative Commons licensing system in works like this.
Yeah, it looks like it really started to take off in about 2008. It had sort of slow growth between the early part of the decade up to about 2007, 2008, and then it just really launched itself. So apparently lots of people know about Creative Commons now and are using it, so that's a good thing. We've got a resource and a tip of the week for you. The resource of the week is from the Library of Congress, which I was interested to see actually is archiving some law blogs. So you can check out the Library of Congress's legal blog archive. It has over, it started harvesting legal blogs in 2007, it says. It has not very much material in it, but one must assume that they will continue to add to it. I think it has a couple of hundred entries now on topics like technology and law, intellectual property, legal ethics, all of these various topically organized categories. So it's nice that Congress is keeping track of the legal blogosphere and providing a resource for folks to use this for research. So that's our resource of the week. And then my tip of the week, and if Evan or Tim have tips too, I'll toss it over to them. But I did want to highlight Zynga's Privacyville, which the tip to be gleaned from this is if you're going to have a convoluted privacy policy and perhaps privacy practices that come under fire and scrutiny, as Zynga has had, why not try and make your privacy policy or the explanation of it at any rate into a game, which is what Zynga has done with this Privacyville thing. Cash Hill wrote about it over at Forbes. And, she says it's not very fun, but it gets the job done. That's her headline. It's not like terribly compelling gameplay, but you're going to learn about how the privacy policy works. So it does accomplish a goal. Kashmir Hill also had this great comment that if you made it more like Oregon Trail, maybe it would be more compelling. Whoops, you gave your credit card number to a spoof site. Water buffalo stole your identity, lose life points. So my tip of the week is for others to be similarly creative like Zynga and think about if you do have privacy policies that impact people and might be difficult for them to understand, try something innovative to get that point across. Evan, did you have a tip for us?
I've got one of a couple of different options. I'll give you some choices here. There's two articles I have. One is man accused of pretending to be a lawyer will represent himself. And the other one is woman pays $10,000 for non-visible work of art. Which one would you like to hear about?
Let's go with the latter.
Okay, woman pays
non-visible art for $500.
Yeah, for $10,000 actually. She paid $10,000 for a piece of non-visible work of art. This may be a joke. I mean, this is not The Onion. This is on the NPR blog, The Two-Way. So, and this is an article that came out on a couple days ago on July 21st. Actor James Franco created this piece of work that exists only in his mind. And amazingly, a woman paid $10,000 for a piece titled Fresh Air, which is a unique piece. Only one is for sale. It's like an endless tank of oxygen. And the purchaser, Amy Davidson, the Huffington Post interviewed her, and she said, as a new media producer, I identified with the ideology of the project and was particularly inspired by the sentence, we exchange ideas and dreams as currency in the new economy. Doesn't that sound really Jeffersonian about lighting a candle from the taper of one another? So something like that. So in any event, I guess the tip to be gained from this is, be diligent in what kind of copyright rights you're going to get in a piece of art that may indeed not exist in a tangible medium of expression, because even though she's paying $10,000, this really seems like one that would be lend itself to being infringed upon because it doesn't meet the threshold requisite of copyrightability, being that it exists only in the artist's mind. So that's my tip of the week.
You could say she's a dreamer, but perhaps not the only one.
That's
what about
right.
you, Tim? Any tips you want to share before we get out of here for the weekend?
My tip is that obviously modern art sucks. This is. I'm surprised it didn't win the Turner Prize. I mean, this is the end of the cul-de-sac of modern art, which has taught us that the highest form of praise an artwork can receive is it makes you question what art is all about. When if I were an artist, the last thing I would want my audience to do would be sitting around scratching its head wondering, is this a work of art? Right? I would want to be expressing myself and have them understand that it was a work of art. What is it saying? Right? So that's my tip of the week: is avoid modern art and read Shakespeare instead.
There you go. Always good advice, although I personally like a blend of both. So let's keep things eclectic and well-rounded here on TWiL. All right. Well, I really appreciate a great and very high-level discussion today on some incredibly important issues. Tim, wonderful to have you on the show. Appreciate all your insights and thoughts. You can find folks, you can find Tim at his blog Free Space, which is at sandefur.typepad.com. And his book, The Right to Earn a Living, is on Amazon, taxed or not, and in other outlets. Anything else you want to share with us, Tim, before we go?
Thanks for having me on. I hope to come back again.
Oh, we'd love to have you back again. Evan, this was fun, huh?
It was really fun. Tim, what a great conversation. You're a sharp guy. It's been great. I've really enjoyed it. Great to talk with you.
Thanks.
And folks, don't forget to look up Evan when you're not watching the show. He's doing all kinds of interesting things online too. He's at internetcases.com. He is at the law firm Hinshaw and Culbertson in Chicago, and he is Internet Cases on Twitter. Thanks again, Evan. Great to see you.
Right on. Thank you.
And thank you all for listening. We record the show live on Fridays at 11 o'clock Pacific, 1800 UTC at live.twit.tv. We love it when you can join us live. But if you can't, you can find the show in iTunes, on your Roku box, and in whatever means that you pretty much like. You can go straight to the twit.tv site /TWiL and find all our archives there for shows going back to the very beginning of TWiL. And the audio for them and the video is there as well. So thanks so much for joining us. You can email me, Denise, at twit.tv with any thoughts you might have, any topics you might like to see us tackle. And you can find me over at my blog, bagandbaggage.com, on Google+. I'm Denise Howell, and on Twitter, I'm @dhowell. And I check those things regularly, too. So take care, all. Have a great weekend.